evening and welcome back to the current affairs lecture series that we have been doing. This week we have taken 5 important topics covering majorly economy, polity, and other recent current affairs. Okay. The first topic at hand today is Supreme Court to have the full strength of 34 judges. Okay. That means now Supreme Court will be having a full sanction strength of 34 judges as 2 new judges have been appointed. Right. What we'll be doing in this one is we will be looking at what are the new appointments and what is the strength of the Supreme Court, what are the constitutional provisions regarding that, who makes appointments and all. Okay. So we are going to look into this lecture as to what is the process of appointment of the Supreme Court judges, okay, and what is the strength, who decides the strength of the Supreme Court judges and all these. So why is news? Because Supreme Court to have, this is a news clipping from the Hindu, 2 new judges have been appointed to the Supreme Court, okay. Now, strength of judges of the Supreme Court. Article 124 says that there shall be a Supreme Court of India consisting of a Chief Justice of India and such number of judges as prescribed by the Parliament by a law. That means, who will prescribe the number of judges? Not the executive, but the Parliament. The legislature will prescribe the number of the judges. Okay. So, Article 124, there shall be a Supreme Court of India consisting of a Chief Justice. That means there shall be a judge who will be the Chief Justice of India and other such number of judges as the Parliament prescribes by law. That means whenever there is a statement that Parliament prescribes by law, that means there shall be an act made by a Parliament. Okay. Whenever, okay. So Parliament by law means, what is Parliament? Parliament is a legislative body. What is its work? Its primary work is legislation, making laws. That means the Parliament will make law to ensure certain strength of the Supreme Court judges. Okay. Now this article has been taken from the original part of the Constitution. Originally there were 7 judges. Okay. 7 judges in the Supreme Court. Now, since the Parliament has got this power to increase or decrease or to prescribe the strength of the judges, the Parliament, in the pursuit of that power, has time to time making laws and making amendments into those laws to ensure the strength of judges in the Supreme Court. So the basic law is Supreme Court Number of Judges Act 1956, and it has been amended from time to time to increase the strength of the judges. Currently, the strength is 34, including the CJI. That means CJI plus 33 judges. Okay. That means CJI plus 33 judges. Right. Great. Now you can see this infographic has been taken from Supreme Court Observer. It's a website. In 1950, when the Constitution was adopted and when the Supreme Court whole independence thing came into action, and although we became independent in 1947, the Constitution was adopted on 26th of November 1950. And then in 1950, the number of Pucine judges means the judges presiding in the Supreme Court of India or whichever court we are talking about, right? So in 1950, there were 7 judges, 56 में 11 judges, फिर 14, 18, 26, 31, 2019 में 33 plus 1, that is Chief Justice of India. The total strength of judges is 34. यानी 33 plus 1. Now, if you look at the criteria for the appointment of judges, why? Because we are talking about the appointment of two new judges, which has taken the strength of the bench of Supreme Court to 34, and 34 is the full sanction strength. Sanction strength means what law prescribes, okay? And when the sanction strength gets filled, that means the strength is full, the bench is full. So what are the qualifications? The first of all, he should be a citizen of India, right? Second is, he should have been a judge of High Court or High Courts for at least 5 years. Okay, either one High Court or multiple High Courts for at least 5 years. Or he should have been an advocate of High Court or High Courts for at least 10 years. Okay, he should have been an advocate of High Court or High Courts for at least 10 years. Or he should be a distinguished jurist. Okay, he should be a distinguished jurist in the eyes of the president. He should be a distinguished jurist. Okay, there's a distinction between the qualification of Supreme Court and High Court judges, right? So of course, this will also be different for Supreme Court and High Court judges. Fine. For High Court, for appointment as a judge of the High Court, the stipulated time period is not 10 years but 7 years. Okay. But one important thing is, if you look at this point 4, he should be a distinguished jurist in the eyes of in the opinion of the president. This is a very distinctive clause in this article, specifying the qualifications of the president of the Supreme Court, of judge of the Supreme Court, that a distinguished jurist can also be appointed by the president as the judge of Supreme Court of India. This is not one criteria in the High Court judges. Matlab, a person who is distinguished jurist can be appointed only as the judge of the Supreme Court and not as the judge of High Court. Okay, तो this is very important. तो एक अगर प्रीलिम्स का क्वेश्चन आता है तो ये आ सकता है, ठीक है, प्रीलिम्स में, कि they can give this point to confuse you in the appointment of High Court judges, and this is very important qualification. This has been asked multiple times in UPSC prelims and other state exams also. So they can simply ask these 3 points, है ना? So it is very important to remember them. And the very important point to remember is कि the distinguished jurist वाला जो point है, that is not applicable to the High Court judges. It is only applicable to Supreme Court judges. Another important point is no minimum age has been prescribed. Okay, no minimum age has been prescribed. Judges of the Supreme Court are appointed by the president. Now, a very interesting evolution in the history of appointment of judges has taken place. Okay. Why? Because the constitution says that judges of the Supreme Court are to be appointed by president in consultation with the Chief Justice of India and other such judges of the Supreme Court as he deems fit. Means Supreme Court के जो judge होंगे, they will be appointed by president. Of course, appointment is being done by president, but the president should take consultation with the Chief Justice of India and other such judges as he deems fit, and these judges should be from the Supreme Court itself. Okay. Now the second point, this one is the first point. Now if we highlight the important points here, that we are going to discuss, right, they are after the consultation of Chief Justice of India and other such judges of the Supreme Court. Okay? It is related to judges of the Supreme Court, the appointment of judges of the Supreme Court. Okay. Now, if we talk about the appointment of Chief Justice of India, Chief Justice of Supreme Court is the Chief Justice of India, right? If we talk about the appointment of Chief Justice of Supreme Court, the President shall consult the such judges of Supreme Court and the judges of High Court as he deems fit. That means the President can appoint a judge to a Supreme Court only after the consultation with the Chief Justice of India and other such judges of the Supreme Court as he deems fit. And the second point being, this the President can appoint a Chief Justice of Supreme Court after the consultation with such judges of Supreme Court and of High Courts as he deems fit. That means in the appointment of Chief Justice of India, he needs to take the consultation of High Court also, the judges of the High Courts also. But in the case of appointment of the judges of the Supreme Court, he does not need to take the consultation with the judges of High Court. Understood? So I hope you understood. Now, धीरे धीरे क्या हुआ कि the Constitution of India is lexically like it is often called what the paradise of lawyers because of the wordings. ठीक है, जो legal lexicography है अपने Constitution की, that it is such a way, it is written in such a way that it is open to multiple interpretations. ठीक है, and that is why there are a lot of litigation related to constitutional issues, because every time a new person comes with a new kind of interpretation and then Supreme Court interprets it, and we know that Supreme Court is the final interpreter of the Constitution. Supreme Court is the final interpreter of the Constitution. यहाँ पे भी एक क्वेश्चन बनता है प्रीलिम्स का कि who is the final interpreter of the Constitution in the Parliament of India? Supreme Court is not the final interpreter of Constitution in Parliament of India. In Parliament, respecting Speaker of Lok Sabha in Lok Sabha and Chairman of Rajya Sabha in Rajya Sabha, that means the respective speakers, the respective chairmans or the respective presiding officers of the Lok Sabha and Rajya Sabha, they happen to be the final interpreter of Constitution and its provisions inside the Parliament of India. Okay, and one important thing is कि there is an article referring to independence of Parliament. That means the parliamentary function cannot be challenged in Supreme Court. Okay. Similarly, that is a very important point to maintain what? The separation of powers between legislature and the judiciary. Okay. So that is very important point. What important point was कि the proceedings of the Parliament cannot be challenged in the Supreme Court or in any court of India. That means Parliament is independent to conduct its proceedings. Okay. That does not mean any law made by the Parliament will not be open to challenge. Any law made by Parliament will be open to challenge in Supreme Court, but the proceedings of the Parliament, okay, that will not be open to challenge in Supreme Court. Okay. That means there exists a separation of power between legislature and judiciary. Now what happened was कि यहाँ पे conflict arise हो गया. Now very important point is कि very important point is, does President appoint judges on its own? Judges on its own? No. As we know, the President cannot make a decision without the aid and advice of the Council of Ministers. Okay, that is, the President cannot make a decision on his own unless and until a discretionary power has been endowed onto the President for exercise of certain jurisdiction or certain power. Unless and until that happens, the President is not empowered. The President is not empowered to take any kind of action on his own. He has to consult, because very clearly there shall be a Council of Ministers to aid and advise. Okay? Because that means the President cannot work on his own. There's a difference between the scope of powers of President and the Governor. Governor has more discretionary powers as compared to President, right? So that means the President is not having a lot of discretionary powers, and this power of appointment of judges also is not a discretionary power of President. What he does is he takes the aid and advice from the Council of Ministers. So what happened was कि a President अपने से appoint कर नहीं सकता. He has to take in, he is bound by the aid and advice of the Council of Ministers, right? So very important point and interesting as well, that President is bound by what? Is bound by aid and advice of Council of Ministers. Okay, there shall be a Council of Ministers to aid and advise the President of India. Okay, all the executive functions in India are taken in the name of the President. Okay, but President is bound by the aid and advice of Council of Ministers. तो पहला क्लॉज तो ये हो गया. दूसरा क्लॉज ये है कि President should consult whom? Chief Justice of India plus Supreme Court judges. Okay, that means he should consult Chief Justice of India and Supreme Court judges. तो यहां पे प्रेसिडेंट का कोई तो फंक्शन ही समझ में नहीं आ रहा. What should the president do? Right? First of all, he is bound by the aid and advice of Council of Ministers. Secondly, for appointment of judges of the Supreme Court, he should consult CJI and Supreme Court judges. तो इस सारे प्रोसेस को सिंप्लीफाई करने के लिए मिनिस्ट्री ऑफ लॉ एंड सुप्रीम कोर्ट ने मिलकर एक मेमोरेंडम ऑफ अंडरस्टैंडिंग साइन किया कि हाउ आर वी गोइंग टू अपॉइंट जजेस. ठीक है, तो बेसिक जो स्ट्रक्चर ऑफ या हायरार्की ऑफ फंक्शनिंग है वो इस तरीके से है कि देयर एग्जिस्ट्स अ कोलिजियम सिस्टम. ठीक है, कोलिजियम सिस्टम. Collegium system is a collection of such judges, ठीक है. तो what collegium system does is it includes CJI plus judges of Supreme Court judges. ठीक है. Currently it has 5 members, including the Chief Justice of India plus 4 other members. Okay. So what happens is collegium decides upon the names of judges to be appointed. ठीक है. तो अब इंडिया में बहुत सारे जजेस हैं और बहुत सारे ऐसे एलिजिबल पर्सन हैं जो सुप्रीम कोर्ट के जज बन सकते हैं. राइट? दे ऑल सेंड देयर नेम्स टू कोलिजियम. राइट? एंड नाउ कोलिजियम कंसीडर्स दीज नेम्स एंड देन इट सेंड्स इट टू मिनिस्ट्री ऑफ लॉ मिनिस्ट्री. Basically, Ministry of Law is under what? It is Ministry of Law is executive, right? So basically, Ministry of Law is under, of course, an executive body. Basically, it is sent to Council of Ministers, right? And upon pondering upon these names, which the CGI has sent, COM, Council of Ministers, advises President to appoint such persons as the collegium has sent. Right? That means collegium sends the advice to Council of Ministers, and now Council of Ministers advises President to appoint such people as the judges of the Supreme Court. Right? I hope you understood this. So this is how consultation functions in Supreme Court of India. But there was a lot of conflict. Okay. So what happened was, there was a conflict on this word as to what amounts to consultation, because consultation can have multiple meanings. Like, is consultation meaning concurrence, or is it just taking advice from the CGI? So what happened was, there were 3 main cases: the first judge's case, second judge's case, and the third judge's case. Okay. So why these judges case happened? Because of the conflict on the word what? Consultation. Okay, consultation. So why? What executive thought means, what cabinet or what executive thought was, consultation means advice. Okay, advice. What judiciary thought, consultation means concurrence. Okay, concurrence means sorry, the President is bound by the advice tendered by Chief Justice of India and such other judges that he has sought the consultation from. That will be concurrence. Advice means he is not bound by the consultation that he has taken from the Chief Justice of India and such other judges. Okay. That means there was a conflict on this word consultation over the meaning of advice or concurrence. So what happened in first judge's case? In first judge's case, in 1982, consultation does not means concurrence but exchange of views. ठीक है? तो consultation doesn't mean concurrence but exchange of views. Supreme Court said that consultation does not means concurrence. That means the executive is not bound by the advice tendered by the collegium of the judges. It must seek that advice and act accordingly. Act accordingly doesn't means necessarily that the executive is bound by the advice of the collegium. That was the recommendation in the first judge's case. First judge's case में क्या हुआ कि concurrence not equals to consultation. Consultation is not concurrence in the first judge's case in 1982. फिर second judge's case में the Supreme Court reversed its earlier decision. In 1993, Supreme Court reversed its earlier decision and said that the consultation implies concurrence of the Chief Justice of the advice tendered by Chief Justice of India is like there should be a concurrence of opinions. That means the President is bound by the advice tendered by Chief Justice of India. Okay, that is concurrence. Now it was reversed. This judgment was reversed in second judge's case 1993, and concurrence implied consultation implied concurrence. That means the President is bound by the advice tendered by Chief Justice of India. But one important caveat that was carved out by the Supreme Court was that the advice tendered by Chief Justice of India is not his sole opinion. Okay, the advice tendered by the Chief Justice of India is not his sole opinion. That means the advice should not be of only the Chief Justice of India, but CJI must also take advice of at least two of his senior most colleagues. In second judge's case, what important thing came out was, first one was consultation is concurrence. ठीक है? That means the President is bound by the advice tendered by the Chief Justice of India. The second point was the opinion of CJI that he tenders to President is not his sole opinion, but he must also take advice from two senior most judges. Okay, of Supreme Court. That means the advice should be formed within the Supreme Court's three senior most judges, that is CJI and two senior most other judges. मतलब at least तीन judge जो senior most हो, they will form an opinion which will be then tendered to the President. And then came the third judge's case. Again, consultation is concurrence was upheld, and यहाँ पे collegium system का evolution होता है. The system that we saw recently, how a collegium advises, sends its recommendation to executive. Now executive advises President to appoint these people. Why? Because the appointment is done by President. Okay. Should consult a collegium of four senior most judges. Now a concept of collegium comes into being. पहले क्या था? Two senior most judges have to be consulted. Now four senior most judges have to be consulted, and not only that, if the concurrence of opinion within the collegium does not exist, then the recommendation does not need to be sent. Okay. यहाँ पे एक important point है. What is that? कि थर्ड जजेस केस में अगेन concurrence is equal to consultation. Basically consultation means concurrence. The second important point was that CJI, ठीक है, the opinion tendered by CJI to the president is not the opinion of CJI himself, but he should also consult 4 senior most judges of Supreme Court. ठीक है, 4 senior most judges of Supreme Court. And even if 2 judges give adverse opinion, okay, even if 2 judges give adverse opinion, the advice need not be sent. The advice need not be sent. Even if 2 judges give adverse opinion, the advice should not be sent to the president. That means within the collegium itself, a concurrence over the names of the judges should exist. A concurrence, that means a commonality of opinion, okay, should exist within the collegium. This is called collegium. ठीक है, and thus collegium system evolved. अभी भी यही system is in function, right? फिर फिर 99th Constitutional Amendment Act 2014, ठीक है, 99th Constitutional Amendment Act 2014 brought National Judicial Appointment Commission. Okay, National Judicial Appointments Commission, collegium system was abolished and new commission was brought for the appointment of judges to the Supreme Court of India. ठीक है, तो NJAC was brought by 99th Constitutional Amendment Act, although the Supreme Court invalidated this NJAC and held it constitutionally invalid. Okay, so NJAC does not exist anymore. It was what? It was invalidated by the Supreme Court of India. ठीक है, on the grounds of separation of power between the judiciary and the executive. Why? Because NJAC was a commission for appointment of judges, okay, but the commission constituted of Supreme Court the Chief Justice of Supreme Court, 2 judges appointed by the Chief Justice of India, Law Minister himself, and 2 eminent persons. 2 eminent persons will be appointed by the Government of India. So the composition, Supreme Court said that the composition of NJAC is such that the executive is trying to interfere with the appointment of judges in the Supreme Court, and this can have larger ramifications in the terms of hampering the independence of the judiciary. That is why NJAC was struck down. Okay, NJAC was struck down, and hence in the 4th judge's case, this is called 4th judge's case, NJAC was struck down and 99th Constitutional Amendment Act was held invalid, constitutionally invalid. So I hope you understood why NJAC was struck down, on the grounds of independence of judiciary, and independence of judiciary is a basic feature of constitution. Okay, the again basic feature of constitution doctrine is very important. Why? Because Supreme Court and other courts have gone over and over again to test the constitutional validity of many such laws on the basis of basic feature of the constitution. Now this characteristic, this special jurisprudence of basic feature was evolved in Keswanand Bharti case 1973. 1973 में केशवानंद भारती केस में basic feature of the constitution doctrine evolve हुई, and what was, in a very brief, if I would like to summarize it, the basic feature of the constitution doctrine is nothing, no rocket science. It says that the parliament has the power to abrogate all of the constitution, has power to amend all of the constitution, provided that the basic feature of the constitution does not change. Okay, that the basic feature of the constitution does not change. Now time and again Supreme Court has prescribed what are the features of basic feature of the constitution, and independence of judiciary is one such feature. Independence of judiciary is one such basic feature, or the fundamental feature of the constitution, that cannot be abrogated, that cannot be taken away by the parliament, and hence NJAC is constitutionally invalid. I hope you understood this. This was very interesting. First judge's case, second judge's case, third judge's case, and fourth judge's case. And this is how judiciary has been evolving, and a conflict, a tussle of power basically between the organs of state, that is the executive, judiciary, legislature, is a consistent tussle. Okay? There's always a there's always there's always a power tussle between all three organs. Still, the three organs are the very essential organs of the governance or the state, right? I hope you understood this. If you have any doubts, you can kindly ask me in the comment section.